And one is the front end of the arbitration problem, which is the enforcement of the arbitration agreement itself, the very beginning. It could also arise at the very end of the process, at the point of enforcement of the arbitration award. And that is because the New York Convention anticipates that at the stage of award enforcement, the court that is asked to enforce the arbitral award may determine whether or not the tribunal that made the award had the jurisdiction in the first place. So, before we begin our discussion of these cases, let's take a look at that provision of the New York Convention. And in fact, let's take a look at both provisions of the New York Convention, the front end and the back end. So take a look at Article 2, 3. This is the provision that we referred to already, but let's take a look again. It's the provision that says the court of a contracting state will seize of an action in a matter with respect of which the parties have made an agreement within the meaning of this article, shall at the request of one of the parties refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. So it's the unless it finds. All of these, some of these cases that we're going to be reviewing today are concerned with what does it mean unless it finds? What is the level of scrutiny that the court must perform before referring the matter to arbitration? Right? It clearly says that unless it finds, that means it needs to find, or it needs to fail to find that it doesn't fall under any one of these three categories. So, and here's how it actually comes again at the enforcement stage. Take a look at this. So, A and B, these are the parties. They are bound by this putative contract. We're not sure whether it's valid or not. If it is valid, the case goes to arbitration, whoever decides it. If it's not valid, then of course the court adjudicates the controversy. But the way it comes about, the way the controversy about the contract itself arises, there are two possibilities. There might be multiple possibilities, but fundamentally there are two possibilities. One is A wants to go to court, therefore initiates a legal action. When A initiates a legal action, disregarding the availability, the existence of a contract, B, who wants to go to arbitration, appears before this court, right, and says that because there is a valid arbitration agreement, the court must refer the case to arbitration. And of course, the court is then asked whether it is incapable of being performed. It's null and void. So that is the question that the court is going to have to determine whether it finds, unless it finds, that's what the law says, whether it finds those three things. The second possibility is, before A takes that action, B goes to arbitration. When B goes to arbitration, A appears before the arbitral tribunal and tells the arbitral tribunal that there is no valid arbitration agreement. Then the arbitral tribunal must determine whether or not the arbitration agreement is valid. Now, listen to this. In this particular instance, the arbitral tribunal is actually now bound by the New York Convention. the rule of decision must come from a different contract law. And that contract law could be one that is selected by the parties, or in the absence of such selection, the arbitral tribunal has to find what contract law must govern the parties' relationship by applying confidence of law rules or whatever it is that they're going to do. Next class, we're going to talk about how that law is identified or selected. But for now, it's enough to know that if this is what is happening, the arbitral tribunal is actually not looking at the New York Convention at all. It's looking at substantive contracts law that comes from a particular state, a particular domestic substantive law of contract that parties might have selected or that the tribunal selected for them. So what we are talking today, what we're talking about today is not very specifically this issue of the tribunal deciding the validity of the arbitration agreement and hence its own jurisdiction on the basis of the law that the parties have selected or somebody else selected for them. What we're looking at is the court's review jurisdiction, the court's jurisdiction to determine the validity of the arbitration agreement. The standard of review that the court applies to determine whether or not the arbitration agreement is valid or not, or the scope of that review, the extent of that review before it actually enforces the arbitration agreement. That is one. Okay? The second one relates to Article 4. Look at Article 4 of the New York Convention. Let's read the first part and then you'll see how that is related to this inquiry. So it says, recognition and enforcement of the award may be refused at the request of one of the parties. A, the parties to the agreement refer to Article 2 where under the law applicable to them, where under some incapacity, or the said agreement is not valid under the law to which the parties have subjected, or failing any such, under the law of the country where the award was made. See? At the end of this whole process, if this thing succeeds, if this arbitration succeeds and there is an award, and this award has to come back to this court, assuming that this is the seat of the arbitration. And again, A, the guy who did not want to go to arbitration, is going to raise the validity of the arbitration agreement again. Here. What is he going to say? He's going to say the tribunal lacked jurisdiction to adjudicate the arbitrate this matter and render an award. Therefore, the court will have that opportunity to review the validity of the arbitration agreement. In other words, whether or not the tribunal made an award without having the jurisdiction to do so. So that is a second look. So there are two situations here. First is this situation whereby the validity of the arbitration agreement and the tribunal's jurisdiction is litigated before the tribunal does anything. The second one is assuming that the other party went to arbitration. The party who wants to stay in court would challenge the validity of the award itself on the basis of, the tribunal never had the jurisdiction in the first place. if that is based on Article 1A of Article 5A of 1A of the New York Code. See, some of these cases are front-end cases, some of them are back-end cases. So that's how they were selected. Okay? So that is the basic framework. Is that clear to everyone? Okay, let me repeat. This is very essential. So it's important that everybody understands it, right? Let's go back and discuss this a little bit more. These are the scenarios. Party A and Party B have a contract. One party thinks that the contract, which is the arbitration contract, when I say contract agreement, arbitration agreement, I should say arbitration agreement here. Arbitration agreement. So one of the parties believes, or at least argues, that the contract, the arbitration agreement is valid. If that party succeeds in convincing the court that the arbitration agreement is valid, what must the court do under the New York Convention? Exactly. Refer the case to arbitration. So that means it's valid. But before the court finds that it is valid, what must it determine? What are the grounds of invalidity under the New York Convention? The other guy is going to come before the court and say what? If he doesn't like the contract, the arbitration agreement, the guy who does not like the arbitration agreement is going to tell the court what? Exactly. So if the court finds any one of those things, the arbitration contract is said to be void, right? Invalid, therefore there is no arbitration. That's the end of the case. The result is the court would continue to adjudicate the controversy. That is one possibility. The second possibility is that the court might find one of those two things that does not exist. No invalidity, no inoperability, or no null and void, in which case the court somehow finds that it is valid, at least on its face. We'll see what kind of standard of proof they use. If the court does not find any problems, it enforces it, but if it finds problems with it, it's going to adjudicate the controversy itself because the arbitration contract is said to be invalid. Now, the second scenario is, forget the court process. A is faster than B. He wants to go to arbitration. Instead of going to court and asking the court to determine the validity, it actually goes to arbitration. It sets up an arbitration tribunal. And further, the arbitral tribunal goes ahead with arbitration and issues an award. The award may be challenged on grounds of lack of jurisdiction in the first place at the award enforcement stage. That's why it comes back to this court for a second review. That is, even if the tribunal itself had decided that it had jurisdiction, the competence, who decides, it decided that it decided, right? So it took the liberty of deciding its own jurisdiction and said, yes, we do have jurisdiction, and yes, we have the right to decide whether we have jurisdiction or not. That's competence, right? So they had to make two decisions. First, they had to decide, is it for us to decide whether we have jurisdiction? Yes. Do we think we have jurisdiction? Yes. If they answer both questions affirmatively, then they go on and arbitrate. But that's not the end of the story, because they cannot enforce their own award. These are private people. A court must enforce the award. So by the time it comes back to the court, the New York Convention permits the court to look at whether or not the arbitral tribunal decided its own jurisdictions properly. Now, let me add a little bit of confusion. The first inquiry about whether or not the arbitration agreement is valid in this instance, and the second inquiry are not exactly identical. Why are they not identical? What is the difference? Now, I'll give you 3 minutes to read the two provisions of the New York Convention. The one that we just read. Article 5, 1A. And Article 2, 3. Tell me why I am saying that the inquiry, this inquiry, and this inquiry are not exactly the same. What is different? Look, on its face, they are both about jurisdiction of the tribunal. But they are slightly different inquiries. The inquiry or the analysis that the court must engage in, must undertake, are different. Why? Take 3 minutes, read those provisions, and tell me if you understand this question. Okay, who wants to tell us? Yes.
I think the applicable law is different. So in the first time scenario, as a front-end decision, the court will actually apply the New York Commission to decide the validity of the agreement, like non-void and those elements. In the second scenario, the court will apply the law, the arbitral tribunal applied to decide whether they have an agreement.
Yes, I think that's exactly right. So in the second scenario, what you have is, what law must the court apply?
Local law.
Yeah. So it's one of those two things, right? The law that they're subjected. So if they don't apply, then they don't. although in many cases the New York Convention rules are incorporated into some kind of domestic law and they're essentially the same, but the inquiry is slightly different in that sense. So, as I said earlier, so although these are commonly two possibilities, there are different other possibilities, right? It's possible that A can actually initiate arbitrary proceeding and litigate the validity of the arbitration agreement. It's also possible that B can actually initiate a legal action and get a declaration, the declaratory relief, that the arbitration agreement is not valid. Or any multiple possibilities exist, but fundamentally these are the main possibilities. So as I say, some of these cases are about this, some are about this. We'll see which ones. Right? Okay. Now, I think competence is really the core of this, of international arbitration. It's usually the dispute. If you see many of these cases, they contain that, even when they're talking about something else, there's always that competence, allocation of competence issue. So, the first case is an ICC case by a tribunal cited in Zurich. Under ICC rules, the Egyptian party was disputing the validity of the arbitration agreement. They obviously didn't want to go to Zurich and arbitrate. What was their main objection about relating to the validity of the arbitration agreement? Ambiguity, exactly, of the arbitration agreement itself, right? What ambiguity were they talking about?
There is no ICC in this.
Yes. So the agreement says ICC rules in Zurich, under ICC arbitration in Zurich, and apparently there was no ICC in Zurich. So the party that did not want to go to arbitration said that the arbitration agreement is invalid because of that, because they selected, maybe it's an operator. You selected an institution that does not exist, therefore it must be null and void or incapable of being performed. What was the court's analysis in that, the tribunal's analysis before? They are now before court here, right? They are before the arbitral tribunal. This is what happened. It's the second scenario, whereby the party that wanted to go to arbitration initiated the arbitral proceeding before waiting for the other party to go to court. Right? So it's the tribunal itself deciding the validity of the arbitration agreement. And on the basis of what law? So they refer to the Zurich Civil Procedure Code, right? And the reason is? Why? Did the party select that law? So why were they referring to it?
Because it's a place where the arbitration is held.
Yes, it's the place of arbitration. It's the seat of the arbitration. Therefore, because Zurich is the seat of the arbitration, they were actually looking at the procedural laws of Zurich. And what does the law tell them?
The arbitration is binding even without nomination of the arbitrators by the party in that agreement.
So under their law, there is,
Valid.
yes. So look, here is the jurisdictional sources of law. They usually look at the New York Convention, and in almost all cases, the New York Convention is a part of, if it's a signatory state, it's a part of their local arbitration law. It's the Lex Arbitrae Loci. That is the procedural law on arbitration. That's the FAA, the Janet Arbitration Act, the 1996 UK Arbitration Act. Those are the kinds of laws. And they also look at the institutional rules. If it is an ICC arbitration, ICC has its own arbitration rules. So it's a collection of all of these rules that you need to look at in determining the validity and alterability of the arbitration agreement itself. So what they've done in this case, obviously, is look at the Lex Arbitrae Loci, which in this case happens to be in procedural law. And one of the basic principles they had to first determine was the principle of competence, right? And they said that the tribunal does have the jurisdiction to decide its own jurisdiction. If that principle didn't exist, what would happen? What would happen? Do you just simply go to arbitration, or do you need to do something else? If the principle of competence did not exist, a party who wants to arbitration needs to do what before initiating an arbitral proceeding? Yeah, go to court and have the court refer the matter to arbitration. But in this case, what they've done is just directly go initiate an arbitral claim, and then set up the tribunal, told the tribunal that it has jurisdiction, that there is no problem with the validity of the arbitration agreement, and the tribunal agreed. They said, yes, we do have the jurisdiction to decide our own jurisdiction, and therefore we find that we have jurisdiction, there is no problem with this thing. And then they adjudicated the merits of the claim, and then they issued an award. That's what they did, right? Now, the Egyptians had another objection about the validity of this arbitration agreement. What was that? One is about the ambiguity in the agreement itself, right? It's a Zurich, and there is no Zurich ICC. But the tribunal said, what? Oh, we understand what they meant. They probably meant some kind of ad hoc arbitration under the ICC rules. So they interpreted it in the way they liked. But the Egyptians also had a second objection to this validity of the arbitration. What was it?
Violation of
Public policy, right? What was it? Yes. Remember that case that we talked about last time? We talked about some states in old laws. In these days, that it's very, very rare that we find. But in the old days, they had laws that said, unless you actually name the arbitrators, the arbitration agreement is not valid, or identify a class of arbitrators. The arbitration agreement is not valid. You recall from our last discussion why some laws provide for that? What is the policy reason behind forcing parties to actually name the arbitrators in the agreement?
Not nominate the arbitrator, it means they don't give up the right to go to court. So the arbitrator don't have the authority to determine these issues.
So the law is designed to protect who?
Parties.
Yes. Especially what kind of parties?
Consumers.
Consumers, exactly. Remember that insurance case from Paris. It is when the big companies force people to enter into an arbitration agreement. And those guys just sign an arbitration agreement. They don't know who the arbitrators are going to be. And the court in that case said, the law is meant to protect these people against their own ignorance. So some states had those laws in the old times. Egypt was one of those. I don't believe they have those laws anymore. But what that was, they say that violates public policy if you actually enter into a contract and you haven't nominated or you have not identified the arbitrators. So that also was not accepted by the tribunal. Therefore, the tribunal went ahead and issued a final order. That was in 1988. So basically, what we have is an arbitral award by a tribunal whose jurisdiction is being challenged, but made the decision that it had the jurisdiction to decide, and then decided that it had the jurisdiction, and then went on arbitrating the merits of the claim issued. So, the party, if the Egyptian party did not like the outcome, what could have they done? When? At the time of enforcement, they could have brought the same question before whichever court the enforcement is sought. In particular, the chances of this case going to Egypt are very high. And if they go before the Egyptian court for enforcement, and of course they would appear before that court and make the same argument all over again. And when they make that argument all over again, the Egyptian court is supposed to review the validity of the arbitration agreement on the basis of what law? Huh? System. Exactly. They cannot apply their own law because under Article 5(1)(a), it's the place, the seat of the, under the laws of the seat, unless you find there was a selection of laws by the parties. In this case, it doesn't appear that they have selected, so they apply the seat. Swiss law would apply. So it gets a little bit complicated. They may not be able to make this particular argument about the public order issue, but still they have that second possibility, and that's why I said these two inquiries are slightly different because the applicable laws could be different. And of course, if the applicable laws are different, potentially the outcome could also be different. Yes?
Why these two laws is different? Why these two procedures? What is the law applicable to? They have different applications.
Yes, the reason is simply because under the New York Convention, when they were drafting the New York Convention, I don't know exactly why. So as I said last time, when they were including the enforcement of arbitral agreements, this Article 2 provision, Article 2 was not part of the initial design, so they had to put it together at the very last minute. What they ended up doing was, good thing is they said, okay, it has to be enforced, the agreement has to be enforced. The New York Convention requires the enforcement not only of the award, but also the agreement, because if you only make a treaty to enforce the award and not the agreement, the party could just simply say, I don't want to go to arbitration, that's it. If there's no force at the front end, there's the back end, the award enforcement would be meaningless, right? They found out that and they said, okay, let's add a provision on the enforcement of the arbitration agreement. But at that point, somehow, they decided to include a substantive rule about the validity. of the arbitration agreement. And they said the court must enforce unless it finds the agreement is null and void, not operative or incapable performed. They added these three substantive rules. So technically, unless the grounds are any one of these three, the arbitration agreement is considered valid. So to determine whether the arbitration agreement is valid or not, the court is guided by those three principles. And those three principles come directly from the convention itself. Not any domestic law that is selected by the parties or anything like that. So that is one. But when you go to the enforcement stage, the New York Convention says you must enforce unless you find the agreement is invalid under the law that the parties have selected, or failing which, under the law of the seat of the arbitral tribunal. So that law could sometimes be exactly the same as what the New York Convention provides, but sometimes it is broader, sometimes it's narrower. So that's why the result of the two inquiries are not always identical. Okay? It's important to understand that. And it will become clearer when we discuss the choice of law next class. So the outcome of any legal proceeding or any case is essentially determined by one or two things, right? It's the applicable law and the facts of the case. You put the two together, you have an outcome. If you vary any one of those two, the results could be different. The appreciation of fact, it could at times be very subjective, but it needs to be proven objectively. But when you have a set of rules and then a set of facts, you put them together, you have a result. If you change the law, the result necessarily will become different. It gets a little bit too technical, but I think that is to be expected from this kind of course. Okay, let's proceed with the Renault case. Who wants to give us the facts of this case? What did Mr. Renault do? Is he the same Renault as the car?
You want him to purchase?
It says the fortuitously called, right? Not the same guy. But obviously rich enough to buy a $500,000 car. And that's what he wanted to do, right? Or is it pounds? This, I think it's even more expensive. Or euros, I don't know. This is before euros. So this guy enters into an agreement with a British company to buy a car, custom-made car for $500,000. Then what was the trouble? What was the problem?
You want to cancel the order.
Yes. But he had deposited some money. How much?
$100,000.
$100,000. $100,000, I'm sure he buys you a very nice car. But that was just a deposit for him. He wanted the money back. Right? He wanted the money back. And this was where?
France.
This was in Paris, yes. So if you have a legal dispute, ordinarily, against someone who refuses to pay you money back, what do? You go to court, right? You go to court and ask them to pay the money back. But in this case, that's what he wanted to do. But what was the English company's objection to that court proceeding? Yeah. They wanted to go to arbitration and where?
London.
In London. One of the things that is interesting in arbitration is
Place.
it's in London, it's an English company. What they were hoping is they have a better chance of winning there than before a French court, right? That's why sometimes when you talk about, oh, arbitration is neutral, people conclude arbitration agreements because of its neutrality, independence, things like that. It's not always true. And in fact, people usually select arbitration precisely for the opposite reason. They want to take advantage of certain things. So you take someone else's money, you refuse to refund, and you want to take him to arbitration in your own home court, basically. That's what they wanted to do. So, how did it end up before the Court of Cassation in Paris? Someone raise your hands and tell me how it ended up before the French court. Yes.
So I think the lower court needs the application to enforce the arbitration application because it's so the arbitration is not what you shall call it.
So obviously the English company did not initiate the arbitration proceedings, right? What happened in this case was that Mr. Renault initiated a legal action. When he initiated legal action, the English company objected to the jurisdiction of the court by saying,
No jurisdiction.
court has no jurisdiction because
The arbitration clause
is valid.
is valid.
Yeah. Because there is a valid arbitration agreement that requires us to go to arbitration in London, the court must refer the case to arbitration. This is 1994. So it's after the New York Convention. It's got to be after the New York Convention. So the district court says something and the other side something, and then of course the Court of Cassation had to determine whether or not the arbitration agreement was valid. So this is an important case because it identifies the standard of review. See, all the New York Convention says is unless it finds. It doesn't tell us how closely the arbitration agreement must be examined before the court finds whether or not those three things exist. Right? The question, we'll see it from the other cases also, what does it mean before the court finds? Does it mean that the court has to engage in an extensive factual inquiry as if it were the final decision on the validity of that agreement? Or does it just review it just casually on a prima facie basis before it says, here, tribunal, you decide whether the arbitration agreement is valid or not? Those are the questions, right? And that comes from the ambiguity of the New York Convention itself. It does not tell us what standard of proof the court must, how closely the court must review before it finds or fails to find the existence of those grounds of invalidity. Because all it says is finds. Unless it finds. How do you find? Do you, for example, look at documentation before the negotiation, before the signing of the agreement? Do you hear witnesses? What is this guy saying, Mr. Renault, about this agreement? Do you recall? What is he saying?
According to the application form, it's a domestic arbitration and it's not merchant, so the lease is valid.
He's saying invalid, and he raises all those counts of invalidity. But on the facts of the case, does he admit that he actually knew that there was an arbitration agreement? He does not admit. He says that he actually didn't know that there was this arbitration agreement in some annex or whatever they put it. He claims that he at least did not know the details of this arbitration, and he is claiming that he did not assent, he did not consent, or whatever it is, to this particular arbitration. If that's what he's saying, the factual inquiry for the court would be what? Oh, did he know? Is he denying it now? Did he knowingly assent to this particular agreement? That is a difficult question. Right? What do you do if one party says, oh, he knew exactly what he was doing, and he says, no, I had no idea? If those are contested facts, what do courts usually do? They hear evidence, right? Presentation of evidence, witnesses, cross-examination, or depending on what jurisdiction you are. It's a full-fledged merits hearing on whether or not this individual knew what he was doing. The question is, under the New York Convention, when the law says, unless it finds, does it mean unless it finds after deep inquiry on the merits whether the arbitration agreement is valid or not? Or does it simply mean, well, just take a look, see if you think there is some agreement, and then send it to the arbitrators so that the arbitrators will worry about all those intricacies of the merits. So if we believe that there is this principle of competence, and the arbitrators have the competence to determine their own competence, you must defer to their judgment. Send it to them and see what they do about it. It's for them to take evidence and deeper inquiry about whether or not what this guy is saying is true. Right? So that is why this case is very important. What is the standard of proof they are looking at? What is it that they say that the court must do before referring the matter to arbitration? We know that the court must refer if it finds, or unless it finds. So how closely do they need to look at it? It appears like that, right? They just need to see at a very prima facie level. On its face, does it look like it's been signed? Yes. Does it look like this guy was a part of this agreement? Yes. Then refer it to the arbitral tribunal and see what they're going to do about it. And what is the standard that they articulate?
The arbitration agreement is manifestly.
Exactly. That is an important articulation of the particular standard. Unless they find it manifestly null. Manifestly null. On its face, if it appears that the signature was forged, if it appears that this guy was not even there when it was signed, if it had any other very clear manifestations of error, then they would say, oh, perhaps there was no arbitration agreement. But unless they find it manifestly null on its face without inquiring deeper, then they have to refer it to arbitration. Right? This is the approach taken by the French Court of Cassation, and I believe that is still the law there. So you don't engage in a full-fledged factual inquiry about the validity of the arbitration agreement. You just see if it looks okay on its face, and then just refer to the arbitrators with the belief that the arbitrators would then take a close look at the validity of the arbitration agreement. If they find it's valid, they say, yes, we do have jurisdiction. If they find it's not valid, they say, no, we don't have jurisdiction, and they dismiss the case. That means it comes back to the court. Now, if some of you might work in this field, what you will find, I don't want to accuse arbitrators of anything, but a lot of times when you decline jurisdiction, that means it's a loss of revenue, right? Because arbitrators get paid a lot of money. So they have that pecuniary, sometimes, not all the time. Some don't care. They are already wealthy and they have no use for the money. But at times, when a lot of money is involved, I don't know if you know the Supreme Court President, the Chief Justice of Singapore. Do you know him? Sundaraj Menon. He is very prominent in arbitration. So he says, at times arbitrators are businessmen looking for business opportunities. Because in big cases, billions of dollars, potentially taking years, they literally make millions of dollars each. If they say, no, we don't have jurisdiction, that is the end of the case. So there are some pecuniary incentives that usually, not always, but sometimes would in some ways affect arbitrators' judgments. And that's precisely why the principle of competence is a very, very well-liked principle among arbitrators because it gives them the power to decide, right? And that decision is not challenged until the very last minute. That is like sometimes 34 years later, after massive presentation of evidence and hearing. At that point, it becomes, and when they actually dig deeper and they adjudicate the controversy, most of these individuals who get paid a lot of money, they do an excellent job, usually. I mean, they know this stuff. In many cases, they kind of get to the bottom of because they're fairly well compensated and they analyze the thing, and they do. At times, because of the lack of that checks and balances, you have decisions that are biased, that are not appropriate, but in many cases, despite the financial problems or implications, you may get a result that is very well thought out. But anyway, that's the principle that we have, the principle of competence. Competence where the tribunal needs to make a decision on its own jurisdiction. Okay, so we still have 3 more cases to go over, but my suggestion would be when we come back from our 10-minute break, we'll